Mr. Bangert, I want to start to try to ask you a few questions again to go back to this opinion that sometimes has been referred to as the midnight opinion. Originally, if I can, I would like to bring up, please, Stacy, Exhibit 112. Now, can you look at this and determine and help me out and tell me whether or not this is the original draft that y'all did on and presented to the Attorney General on that Saturday afternoon? You need a moment to look at it, or would it help you to have a hard copy?
A hard copy would be helpful, yes, sir.
Can we? And Stacy, do we perhaps have a hard copy for the court?
But I can tell you without looking at it that this is not the original version that we sent.
Now let me follow up on what your observation is. What order would this draft have been?
I'm assuming this is the final draft. It would have been the very last thing that was produced.
Would you look at the first page, please? And the last page, if that helps you.
No, this is not the final draft. I can now see there's no signature on it.
Right. Would you look at the opening paragraph and see what that seems to be saying in terms of the original position you took?
Yes, this refreshes my recollection.
Pardon me?
Yes, this does refresh my recollection as to that.
And now that you look at the language in the first paragraph of Exhibit 112, what does that tell you in terms of which draft or order it was?
This was one of the early...
Now, let me tell you a problem for you to keep in mind. When you look to the left for the iPad, there you go. Perfect. There you go.
There we go.
All right.
Yes, this was one of the early drafts.
And in the first paragraph, would you look at the sentence that begins with "we conclude"? Would you highlight for me, Stacy? Read this paragraph out loud to the jury, please.
Yes. We conclude that a foreclosure sale of residential or commercial real property constitutes a service to which no occupancy limit applies under Executive Order GA 28, and local governmental bodies therefore lack authority to restrict in-person attendance at these sales.
All right. Now, at that time, what was the legal basis for you concluding that there wasn't a restriction and that it could be conducted?
It was GA 28, the governor's order.
All right. And what was it about GA 28, the governor's order? And I may have a copy there. I couldn't locate it on my desk. If somebody finds it, they can bring it up to me. But what was it about the governor's order, and when was that order that you concluded would allow essentially the foreclosure sales to go forward, particularly outside? Thank you very much.
Yes, there were a number of exceptions in the governor's order to in-person gathering restrictions.
With the court's permission, I'm going to mark this as an exhibit number 621. Thank you so much. 631 or 633? 631. Thank you. I'm going to tender it to counsel, Your Honor, because I don't have an extra copy right now.
No objection, Judge.
631 shall be admitted into evidence.
Thank you, Your Honor. Do we have a copy by chance for the court to have up there?
Always nice for the court to have a copy.
This only came up during the lunch hour. I apologize.
Thanks, sir.
And one for him. Thank you very much. Now, I don't know whether or not, and I'm going to ask as we go along, whether Ms. Manella can figure out a way to balance these. First of all, if there's a way to do a split screen here, Stacy, 112 and 115, and I believe I will represent that 115 is the final order. And I believe 115 is in evidence. Now, if you could look at these two orders, is the one on the left, the draft we talked about, Exhibit 112, what your first finding was?
Yes, our first finding is summarized in the first paragraph. We conclude that a foreclosure sale. Yeah, there we go. Thank you. We conclude that a foreclosure sale of residential or commercial real property constitutes a service to which no occupancy limit applies under Executive Order GA-28, and local governmental bodies therefore lack authority to restrict in-person attendance at these sales.
All right, now I'm going to ask you if you could leave that up, please, Stacy, first. And then I want you, if you would, I want you to look over to the government's executive order on page 3.
Okay, and I don't have a copy of the order.
Do we have one more, Mark? No.
Thank you, sir.
Thank you. And I believe that 112 was just never discussed as one of those that you did not object to. I want to tend it to you again to look at. I just looked to make sure. I'm told that 112 is not in evidence, and I apologize. The headlining is not. This is the original draft they proposed to him.
No objection, Judge.
No objection, 112 will be submitted to evidence.
And I apologize for having published that before I realized that that's my fault, not anybody else's. Now, I want to ask you, you referred in your testimony just a moment ago that in your first draft, in which you basically had a ruling that said these foreclosures, particularly outside, would be allowed. And then you said that was partly based on the governor's executive order that he had previously issued. And you talked about it as General Order 28, correct?
Yes, no occupancy limit applies.
I'm sorry?
Yes, no occupancy limit applies under
All right.
GA-28.
And what role can you point us in the governor's General Order 28 to the section that you relied on in that initial opinion that said they could be open to the public? They could foreclosure proceedings could be open.
Yes. May I see the second page of
Pardon me?
exhibit? May I see the second page of Exhibit 112?
All right. We move to second page. Thank you, Stacy.
Yes. Yes, we reference it here. We address your question.
No, I'm sorry, Stacy. What I want to do now is go to, if you have ordered, I don't know if you have 631 loaded, do you? If you do have 631 loaded, could you go to the second page of that? And you can sacrifice the one on the right. You can take down 115 and put in the governor's general order. And by the way, the executive order, before you move, Stacy, that is dated. Can you see on there what date it is? Is it June? Can you see June 20th?
I can. It's June 26th, 2020.
All right. Now, so that executive order, did it not, existed at the time that you were drafting your opinions at the request of the Attorney General?
They did.
All right. Now, what is it on page 2 of the governor's executive order that led y'all to conclude and say in your first draft that foreclosure sales could be conducted?
Yes, if you will go to page 2 of Exhibit 112,
All right, Stacy, if you go to page 2 of
the
the
first
general
full
order.
paragraph.
Pardon me?
The first full paragraph. We point out that Executive Order 28 has a baseline limitation that does not apply to...
I don't, I'm confused here, and it's probably my fault. Stacy, may I approach, please? As usual, Ms. Manello is more on top of it than I. You directed me, and it's my fault, you directed me to page 2 of
Exhibit 112,
112, your initial draft opinion.
the initial opinion.
And I was trying to go over to the governor's order. But let's
yes.
stay with 112 first.
Okay.
So now, Stacy, let's put up 112 and the governor's order. Those are going to be the two on the screens. Go ahead. All right, tell me what it is about 112 that you think is relevant to what we're saying.
Yes, this paragraph that is highlighted,
All
the
right,
second
move it away
paragraph.
from that microphone. You got to move it to
Yes.
you. There you go.
The paragraph calls out the executive order's baseline limitations on gatherings. It then says this limitation does not apply to any services listed by the U.S. Department of Homeland Security's Cybersecurity and Infrastructure Workforce version 3.1 or subsequent version. CISA guidance is how we referred to that. Among the services listed in version 3.1 of CISA are residential and commercial real estate services, including settlement services.
And then if we go down to,
Yeah.
you go down to about a sentence or two down there, you say, do you not? And there is no better indication of that intent than the words that are chosen, correct?
That is correct.
All right, now let's stop there and let's go over to the second page of the general. And by the way, could you just explain to us lay people what CISA is, C-I-S-A? What does that stand for?
It's the Cybersecurity Infrastructure Workforce. CISA is I'm trying to recall exactly what that acronym stood for, but there was a guidance document issued by an agency within the federal government that called out essential services and infrastructure that should be exempt from COVID limitations.
Okay, so for us lay people, essentially, are you saying that you are going from your draft that you did to show why the governor's proclamation or executive order would have exempted it as far as you were concerned when you dropped the original draft, is that right?
That's exactly right. We were trying to demonstrate, and we did demonstrate here, that a straight application of the governor's executive order excluded these types of foreclosure sales from limitations.
All right, stay with me. I don't want to tell everybody how to build a Swiss village when we're trying to just do what time it is. But if we go to page 2 of the governor's order, where in there does it point people to the legal basis you made for your original order?
Paragraph 1A.
Stacy, can you, yeah, on the left, can you do 1A? Thank you. Can you highlight 1A for me? There you go. Mr. Donnelly wants to make sure that I let you know that we can't give you a copy of the CISA document because it's a government confidential document, okay? But having said that, would you explain in this highlighted language how this tells you...
Objection to that sidebar about the CISA document. I don't believe it's confidential.
Sustained.
Can you explain in the highlighted portion here?
Say again?
Yes, explain in a highlighted portion how that impacted your original opinion you recommended in a draft to the Attorney General.
Yes. This was part of the exemptions from occupancy limits, and the CISA guidance called out a number of essential services, infrastructure, among which, as we point out in our original draft guidance, are residential and commercial real estate services, including settlement services.
So explain to the court what that meant as far as the conclusion that you ultimately reached and recommended to the Attorney General.
Based on a plain text interpretation of the governor's order, foreclosure sales would not be subject to occupancy limitations.
If it affected any real estate?
Yes, and that was a straightforward textual interpretation.
So in your original one, did you actually base it upon an exception the governor's executive order had given to say that it should be open to the public?
Yes, it was a straightforward application of the governor's executive order.
Now, how did you get around that then when you were ordered to come up with a different answer? And if we can, Stacy, let's now take down the governor's executive order and put up Exhibit 115, please. Now, tell us what it is about what did you do that, since you had based it on a specific reading of the governor's statute, and now you're being asked to give an opposite view? How did you do that?
Could you go to page 2 of Exhibit 115?
Yes. Where do you want to be?
If you'll look at the third paragraph. We simply jump straight to the general occupancy limits.
Pardon me?
We jump right to the general occupancy limits, excluding conversation about CISA.
Direct us and Ms. Manella where to highlight that you're talking about.
The language, this general limitation, however, is subject to several exceptions.
Where you read?
One such exception is found in paragraph 5 of the order, which limits outdoor gatherings to 10 persons or fewer without approval by the mayor or the unincorporated territory. So we switched out the applicable exceptions in the order to eliminate any reference to the CISA guidance.
So what you did is you just wrote out a paragraph, did you not, of the governor's order?
We determined, based on the Attorney General's instructions to us, that we would no longer apply the exception that had been granted by the governor's order.
When you say based on his instruction, did he actually talk about that language?
No, he told us to reach a different conclusion, and that was the only way to do it.
I don't need it, but thank you. All right. Now, finally, I want to make sure, I don't know that I need to introduce this, but had you read, may I approach the witness very briefly?
Yes.
I'm going to approach you and show you what we have just marked as a new exhibit. House Board of Managers Exhibit 632 is a new listing. I'll tender to the court and the council with the admonition that I don't intend to read all this. So my question to you, though, without having introduced it yet, I will actually make it for ease, move to introduce it. We move to introduce House Board of Managers Exhibit 632.
Judge, I would object to this witness testifying to this document, and additionally, this document has not been produced. There's no bait stamps on this document.
No, that's certainly right. It has not been produced. We never foresaw this issue. So we've just gathered this during the lunch hour and printed it out here, and we've tendered it to him. Whatever his position is fine, but he's certainly right. It's never been produced. We did not foresee this issue.
It's a 40-page document riddled with hearsay, Judge.
It's a government record. I think probably stands on its own. It's a public government record.
Mr. Rosso, do you need time to review this 40-page document?
Judge, if I could have 1 or 2 minutes.
If I may, I think that's a reasonable question, so if I could speed it along, what I'll do is I'll hold withdrawal or wait on the motion to admit it, see if I can elicit testimony that gets the same, it may not become an issue ultimately. But if I do want to, I'll give him notice so he gets time to read it.
Hold on 1 second.
Judge, we're ready to go.
Thank you. Now,
Do you withdraw the objection then?
No, Judge. Judge, may we have 5 minutes to just look through this document real quick? Okay.
Yes.
fine.
We'll stand at ease for 5 minutes.
That's my last copy. Let me put it down. I put it down here. So page. That's all right. I'm fine. Way back. 16. Where's the page number? That's down. Yes, sir. Here shortly. Here we go. This one. Okay. That's what they were. What does that say? Residential. I know. What does that say? And where does it come? Just as an essential function? Yeah.
Mr. Osso, you,
Your Honor, I have no objection to this exhibit. Just for clarification, it was House Exhibit, what's the number, Rusty? No objection to House Exhibit 652. Excuse me, 632.
no objection to 632. Do you want to admit it into evidence?
Yes, please.
Okay.
All right.
House Exhibit 632 is admitted.
I want, if I can, I'm going to walk up to you and I'm going to show you a page. I have, by the way, I mistakenly called this a confidential document. I've looked at it. It is not. It is a public document. There's nothing confidential about it. That's one of 230 mistakes I'll make during this trial.
Objection.
Okay? So now, thank you.
Object to that sidebar.
Excuse me, what is the
Move to strike.
objection?
Sidebar, and I just moved to strike Mr. Hardin's comments.
Yeah, sustain.
Thank you.
You know better than that. There you go.
That makes it 237. Thank you. I'm going to walk up. I'm going to show you where the tab. I'll show counsel where I'm pointing it to. I'll go by him, show him what I'm about to address you to, because I can't send you to a page number. Just a second. Now, on Exhibit 632, is there a provision of it, and I showed you a tab, so there's no secret about this. Is there a provision in this document that you relied on in coming to your conclusions that you presented in your first draft to the Attorney General?
Yes.
And shown in Exhibit? Can you explain? And I don't know that, Stacy, you don't have this loaded, do you? Do you really? All right. Let me show you where I'm going, Stacy, because again, I don't have a page number. May I approach her? Now, if you would, on the screen that she's already anticipated, is there somewhere on this screen that you can direct the viewers to that has any language that you used as a basis for your original opinion that you delivered to the Attorney General on that Saturday afternoon?
Yes, the very last bullet point, residential and commercial real estate services, including settlement services.
And what did that mean to you?
We interpret that in the original opinion.
And then can you read the portion of Exhibit 112? Stacy, can you split it for me? 112, in your opinion, that was really based on this segment, this one little excerpt out of 632.
Yes. Second paragraph, second page. A court's main objective in construing the law is to give effect to the intent of its provisions. And then we footnote, and there is no better indication of that intent than the words that are chosen. Then we footnote, where text is clear, text is determinative of that intent.
Microphone. All right. Keep going.
One dictionary defines a service as work that is done for others as an occupation or business. Real estate is defined as land and the buildings and permanent fixtures attached to it. Thus, real estate services include services performed for others as an occupation or business that pertain to land or the buildings and permanent fixtures attached to the land, insofar as the performance of auction or foreclosure sale services related to commercial or residential real property. Such services are one specific iteration of residential and commercial real estate services.
All right. So, to reduce it down to its basics, in recommending or in your drafting to the Attorney General, saying that there should be no restriction on the foreclosure sales, did you rely on a government document as guidance as to why it would be considered an essential service or activity that was exempted based on the governor's executive order?
Yes, the specific government document referenced and incorporated into the governor's order.
All right. So in effect, in y'all's opinion at that time, was your recommendation that it would be open and they could have foreclosures based on a combination of the governor's order, and if you go to the basic item that they're referring to in the governor's order, that would have said essential services that would have included foreclosure sales for either commercial or real estate property?
Yes.
Residential property, excuse me.
Yes, we conclude that it is not, there's no occupancy limit applicable pursuant to Executive Order GA-28.
Now, when you then were directed to come to the opposite conclusion in the drafting, that is the final product in the exhibit that we've been using, I think is 115, you had a challenge to write around the basis for your first opinion, so what did you do?
Objection to leading and assuming the answer in the question.
Sustain, rephrase.
What did you do to come up with the opposite conclusion you had originally arrived at?
A couple of things. If you go to page 2 of Exhibit 115, we first point to the general occupancy limitations in the third paragraph. Next, we do point ultimately to CISA at the bottom paragraph. And if you would go to the next page, at the very bottom of the first full paragraph, and this is really the kicker, the court's main objective in construing the law is to give effect to the intent of its provisions.
Slow down, please. On behalf of court reporter?
Yes, my apologies.
And the volume on behalf of the people on the floor. Could you speak a little louder, please?
Yes. We repeat our commitment to textualism, which was a guiding star of our office at all times. We then point out that based on our analysis of the words, we believe that outdoor foreclosure sales, last sentence, are not exempted from the 10-person attendance limitation.
And
we completely reversed it.
Excuse me, I'm sorry. What was the only thing that had changed since you had the original opinion?
The direction from the Attorney General.
All right. Now, you had questions about whether or not it would have happened anyway because of other subsequent events. At the time that you drafted these two opinions, did you have any idea that Nate Paul had bankruptcy hearings scheduled?
Objection to asked and answered. And this witness said he didn't have specific knowledge, so speculation.
Sustained.
In this particular matter, did you yourself know about any bankruptcy hearings that were set any foreclosure hearings that were set in the foreseeable future? Just you yourself, were you aware?
Objection to asked and answered.
Not by me.
And lack specific knowledge.
Overruled. I sustained your first objection, which forced him to ask the question a second time.
Thank you, Your Honor. Did
No.
you yourself?
I had no specific knowledge of any specific foreclosure sales.
All right. You were there when he introduced a certain document, and if I can I have Exhibit AG Exhibit 295, please, Stacy? You have heard earlier questions on direct as to whether or not, have you not, sir, these opinions would be of help to somebody who was somebody that was opposing a foreclosure hearing, right?
I recall those.
All right. Now, if you could, can you identify, had you seen before we showed you this Attorney General exhibit, had you seen it before, this exhibit that he's entered into evidence?
No, this is the first time I've seen this document.
All right.
With the cross-examination.
All right. Now, I want you, I'm going to read this to you and ask you what the import of this when you look at the exhibit is. Judge Gamble, August 3rd, 2020. As it is relevant to these proceedings, please see the attached guidance just released by the Attorney General's office. Had been just released, hadn't it? What date was it released?
The 1st.
1st of August. That was a Sunday, was it right?
I believe midnight the 1st. I think that's right, yes.
So this is just Tuesday after you released the opinion on, or after you provided the Attorney General the opinion on Sunday the 1st, correct?
It's 2 days later, yes.
Keep your voice up, away from the microphone.
2 days later, yes.
All right. Regarding the foreclosures may not proceed unless specifically authorized by the mayor in the city of the foreclosure, given the standing 10-person restriction would violate Texas Property Code, Chapter 51. Does the attachment include the opinion that we have just been so laboriously going over?
Yes.
Would you look to the last page of that opinion and see if that's the final one that we identified as Exhibit 115
It is.
with your signature?
It is.
Does the cover page identify on behalf of whom
It
this
does.
particular email, this particular pleading was filed in a court here in Travis County?
Yes.
And who was the person that represented whom
This is one of
was presenting this particular pleading and urging that your opinion was relevant to their case?
This is one of Nate Paul's companies.
Do you even yourself personally know how the judge ruled one way or the other on this motion?
Not in this case, no.
All right. And in fact, are you familiar with any other cases? Nate Paul cited this opinion and seeking to foreclosures in that year of 2020 after you rendered your final opinion?
Only through news reports that came out after.
All right. Was it multiple places?
Yes.
Objection to hearsay, Judge.
I'm through.
Do you withdraw that question?
I think actually he meant to say leading. It was leading, it wasn't hearsay.
No, I meant to say hearsay, but I'll retract the objection for Mr. Harden.
That's all I have.
Recross?
Yes, Judge.
Mr. Rosso?
You just cited the Cybersecurity and Infrastructure Security Act pretty precisely to Mr. Harden on direct examination, did you not?
I had it in front of me.
Okay. You also cited the day of the week that you issued that opinion, did you not?
The day of the week was August 1st when we issued the opinion.
I'm just surprised because you showed an uncanny ability to remember things when Mr. Harden was asking you questions, as opposed to when I asked you about the same documents during my cross-examination. Can you explain that?
I disagree with your characterization.
Okay. We'll agree to disagree. I don't have an e-copy of this CISA document that the House has just produced, but I think Mr. Harden had you reference page 16 of that document, did he not?
He did.
He had you reference the very bottom part that I have highlighted in orange, and I'm going to show the jury. And it says settlement services, correct?
One of the things it says is settlement services.
Now, behind the term settlement services in this document, there is no definition as to what settlement services are.
I do not see a definition.
I don't see the word foreclosure sale or non-judicial foreclosure sale behind it, do you?
The word foreclosure sale does not appear.
Do you have a real estate license?
No.
Okay. Would it surprise you to know that people that have real estate licenses oftentimes engage in settlement services to close on homes?
I would not know.
It deals with title work and things of that nature?
I would not know.
Okay. You won't find the word foreclosure sale in that definition, sir.
This definition? It is not, the word foreclosure does not appear there, but that's why you engage in legal analysis and construction.
Legal analysis and construction, which means that somebody else, another attorney, perhaps the Attorney General, could have a different viewpoint as to what a settlement service is, correct?
He could have any number of viewpoints about that.
That's why they call it the practice of law. Zone of reasonable disagreement. That happens a lot in law, does it not?
Not in this case.
Okay. Well, that's your opinion, but let's talk about facts. Are you aware of whether or not the opinion that you wrote that you said was unconscionable and opposite of Attorney General policy, did anybody challenge that in a court of law?
Did anyone challenge the opinion?
Yeah, the opinion in a court of law.
I'm not aware of it being challenged. I don't know how you would do that under standing doctrine.
Okay.
The witness may step down.
Judge, I have one more question if the court would entertain it.
Will the witness come back? One more question.
Prior to your term as a politician, did you or did you not practice real estate law? No. Paxton practiced real estate law, did he not?
I believe he had some real estate experience back in his past.
Okay. So when you guys are going back and forth regarding the definition of things, it's possible he had some background knowledge of what settlement services meant?
In this case, that was not the best interpretation.
Okay. That's your opinion, sir, correct?
No, that's the law.
That's your opinion.
I disagree.
Okay.
You may now step down. House, call the next witness.
We call Mr. Ryan Vassar.